Good morning to everyone at today's public hearing of the Vetting Commission established under Law Number 65 of the year 2023 on the external evaluation of judges and candidates for judges of the Supreme Court of Justice. I'm Scott Bales, the chair of the commission, and I declare this session open. The hearing is being conducted under Law Number 252 of the year 2023 on the external evaluation of judges and prosecutors and amending some normative acts, and also under the Commission's Rules of Organization and Functioning. The subject of today's hearing is Ana Panov, a judge of the Central Court of Appeal, the court previously known as the Chișinău Court of Appeal. Judge Panov, welcome.
Good morning.
I'm joined by two other panel members. To my right is Commission Member Willem Brouwer, and to my left is Commission Member Yuri Gatskin. Our panel is also assisted by members of its secretariat, and you may notice in the room some members of the media or the public. The photographer will take pictures just at the outset of the hearing for a few minutes. The hearing is being conducted with interpretation between Romanian and English. To allow for accurate interpretation, I ask everyone to speak slowly and clearly. Only one person should speak at a time. Furthermore, the proceedings are being recorded. The recordings of the public hearings generally will be available within 3 days after the hearing on the Commission's website, www.vettingmd.eu. The closed part of the hearing will not be available on the website, but will be recorded and included in the evaluation materials. During the hearing, one or more members of the panel may ask you questions. You should answer them truthfully and completely. Your explanations are important to the panel in assessing your compliance with the criteria for ethical and financial integrity. At the end of the hearing, you will be allowed to make a brief closing statement. In posing questions to you, we will take into account your privacy and, where appropriate and possible, the privacy of family members and close persons. So we will not specifically refer to things like ID numbers, bank account numbers, specific real estate addresses, and we ask that you do the same in order to protect privacy. I will begin by briefly reviewing the evaluation process for Judge Panov. The Commission initiated its evaluation on April 11th, 2024, by notifying the judge by email and asking her to complete and return an ethics questionnaire and the declarations required by Law Number 252. Judge Panov returned and completed declarations and the questionnaire on May 2nd and May 16th, 2024. As part of evaluating a subject's ethical and financial integrity, the Commission also obtains information from many other sources, such as the National Integrity Authority, the State Fiscal Service, the General Inspectorate of the Border Police, other public institutions, financial institutions, and open sources. The Commission assesses the information it obtains for relevance and reliability. Between August and December of 2024, the Commission asked Judge Panov to provide additional information to clarify certain matters during 4 rounds of questions. In each of the rounds of questions, we allowed, at Judge Panov's request, extensions of the time to respond. She did ultimately provide additional information and answers in response to the requests. On January 30th of 2025, we advised Judge Panov that the panel had identified some areas of doubt about her compliance with the ethical and financial criteria, and we invited her to attend today's hearing. On February 3rd, 2025, Judge Panov sent the Commission her request for access to the evaluation materials, and on February 8th, she requested that part of the hearing be held in closed session. The Secretariat provided access to the evaluation materials, and on February 10th, 2025, the Commission sent the judge its decision accepting her request to hold part of the hearing in closed session. Also on February 10th, the judge provided additional explanations via email regarding certain of the concerns identified by the Commission. Judge Panov, do you now wish to make any corrections or additions to the answers you've provided to the request for information? Is there anything in addition to what you've provided to this point that you'd like to identify for us?
I made some mistakes in calculations when it comes to 2015. And when I will be referring to 2015, I will point out the mistakes that I made in the calculations. This is because it's obvious that these are obvious mathematical mistakes. This was because I was in a hurry and because there's a lot of information. I'm working, I have some issues related to my husband, so I made these mistakes. But it's obvious that these mistakes were made when I made the initial declarations on 2015. The amount of savings at the end of the year, I declared 35,000 euros, but actually it was 25. This money was obtained from selling land plot, and after the payment of the taxes, it's 930,000 lei. And if we do the mathematical calculations, we can see that the amounts are different. Also, I would like to add to what is related to the declarations I've sent in written. I didn't mention this because I didn't have this information. I obtained it a bit later on the taxes paid by my husband throughout the verification period. For 2012-2023, it's 2,846,000 lei. And the one clarification related to the pension that I received, because I obtained the salary from the Court of Appeal, but I'm already retired since 2013. So the amount is 2,207,165 lei. So I would like to start with the data that I just presented. So I would also want to present something. Maybe you will allow me to say what I've prepared in written.
Well, as I said earlier, we will allow you to make a brief closing statement. And as to these matters, we may be asking additional questions over the course of the hearing. But at this point, we just want to make sure that beyond the matters that you've identified, are there any other corrections that you want to call to our attention?
I think that now I have nothing else to add, but maybe in the closed session I will mention some things that I would not want to mention now.
Sure. And then let me ask one more follow-up question. With the exception of these corrections that you just identified today, are the answers you provided on May 2nd and May 16th of last year in the ethics questionnaire still accurate?
Yes, the answers that I gave are correct.
And similarly, with these corrections, is the information that you provided in the declarations submitted last May also still accurate?
I think that with these corrections that I've offered for each year, so I explained what is the correction for each year. Because at the beginning, on the 2nd and on the 16th of May, I was still thinking whether to go through the vetting process or not. However, throughout the rounds of questions, I corrected this. And if you ask me some specific questions, I can answer them.
Okay, and again,
You mean the ethics aspects, right? The ethics questions?
Well, it concerns both the financial and the ethics questions, but what we're really trying to make sure is that given what other information you've identified to this point, and I recognize you've identified some additional corrections today, are they otherwise accurate? Is the information you've to this point provided to the commission otherwise accurate?
So if you ask me questions, I can answer. So additionally, I have nothing to say, only if you ask questions.
So sitting here today, you're not aware of any other inaccuracies in the information that you've provided?
No, I'm not aware of this. I'm ready to answer, but so far I have no other information.
Okay, thank you. So we're now going to ask some additional questions. We'll try to keep our questions short and to the point, and we would ask you to try to keep your answers short and to the point as well. Yuri Gatskin will begin the questions, but as we noted earlier, we granted your request that part of the hearing be held in closed session, and we're going to take up those issues first. So at this point, we're going to go into closed session. We would ask the people in the room other than the interpreters and the videographers to please leave, and we will advise people as soon as we go back into open session. Now that we are in open session for the hearing, we're going to have some additional questions by Commission Member Yuri Gatskin.
Madam Panov, for 2013, we've discussed in the closed session. Now I would like to ask you some questions on 2015. According to the information in the hearing notice, you can see that the Commission established preliminary a difference of minus 225,000 lei approximately. But first of all, I would like to ask you on the amount of savings, because in the first round of questions you mentioned it was 35,000 euros. Later you changed it to 25,000 euros in the third or fourth round. Could you tell us why did you revise the amount of the savings? And I've highlighted that I made some wrong calculations. I think it's also because it's been 10 years since 2015. And this time frame caused some mistakes. So according to the incomes of my husband, 930,000 lei from the sale of the land plots. Actually, it was 1 million, and after taxes, 930,000. We took out the amounts that we spent in 2015. So 225,000 was for the purchase of Toyota car, 106,000 for the purchase of the agricultural land, and 1,500 for other expenditure. So so we also had additional incomes besides this 930,000, but it was actually 25,000 because my husband had some health issues. So now he couldn't help me in preparing this data in this period. So he gave me the wrong data. So it was not 35,000, it was 25,000. And in 2015, after the sale of the land, he had different bank transactions because the exchange rate increased, and he converted it into euro and then in lei, and offered some support to the company. Because this is a peculiarity of his activity. because besides these immovable assets, he has lands that he is working, and in the springtime he needs funds to purchase seeds for sunflower, wheat, and corn, things for sprinkling this, and this 543,000 is from the sale of the land plots. But the mistakes were wrong calculations. Actually, it was 25,000, not 35,000, as we declared. So this was a calculation mistake. And I think my husband made some mistakes in terms of the bank accounts he used, because he would use the personal bank accounts for the company, so we needed to have the banking information. And we used the information that we could remember, and also the accountancy information. In 2014, 42,456 were transferred to the company, and another amount was deposited in account. 61,000 purchases from different suppliers probably was from for the company, and 73,000 and 71,000 in 2015 were savings in cash. 171,000 were saving in cash at the end. Are you referring to retail from the card which your husband also used for his company? 456. 42,456. So he needed this because the land is registered on him as an individual, but they were given to the company for its activity. So he made some mistakes because these are his lands, and he made some payments from the personal bank accounts to the company bank accounts. He made payments to the company. And in 2014, I referred, when analyzing in round for the operations, so I mentioned on what dates what payments were done for sunflower, for the substances for sprinkling these crops, the spring crops. And in the end, the sunflower was sold, and the money was deposited in the bank account of the individual and not the company. So in that period when he was at the beginning, he used to make payments both from his personal and from the company bank account. So somehow he made some mistakes. But what I wanted to mention is that the Commission rightly established that in 2012-2013 the incomes were 5,450,000, and this is part of the total income. The taxes were 2,862 million. So we also had the rent for the land plots and others. These are also fiscalized. This is, and the total incomes for the evaluation period were approximately 19 million. Of the small farm, your household together with the small farm. And you say that basically you paid the taxes of 2.8 million. The small farm was paid for its activity 2.8 million. So its activity is transparent. We are not hiding anything. All the earnings are used for payments. Let's go back to 2015. You mentioned that the income from the sale of this 930,000 were used for a loan to the company, a loan of 543,000, and the rest of the funds of this 930,000, how were they used? And I said, out of this, we bought the Toyota for 225,000 from a company as an individual. 106,000, 115,000 was the purchase of the agricultural land, and 15,000 lei was for the chassis, vehicle body. This was what was spent. The rest was saved. Your living expenses mentioned in this table, 102,000 lei, were mentioned as monthly expenditures. I would like to say that you mentioned 102,000 as living expenses, but you also included retail expenditures. So it's a very high amount of 290,000. But maybe you understood something, but not quite clear. Beside this enterprise, my company had a small farm where we grow agricultural products, bioproducts. And we sent pictures, and this also influenced our consumption or expenditure. So I think in terms of these expenditures, 8,000, 3,000, we've included these approximate amounts. But this is also retail and cash expenditure, so it also includes retail purchases. This question was asked to you in the third round of question, and it was mostly related to cash. And this is what maybe led to this unclarity. Thank you. I have no other questions.
Judge, we're going to move then to a different topic. As you know from the notice of hearing, we've referred to a couple of cases that ultimately resulted in determinations by the European Court of Human Rights that there had been denial of rights protected by the Convention. We want to ask you some follow-up questions related to those cases. The first one is what I'll call the Baksha case. It, you may recall, involves a father's effort to enforce visitation rights under a settlement agreement with his ex-wife. The European Court of Human Rights ultimately found that the proceedings in the domestic courts had resulted in a denial of the father's rights under Article 8 of the Convention. And the case that the Court of Appeals was involved in was an appeal by the mother from the father's enlisting a bailiff to initiate enforcement proceedings under the settlement agreement. So do you recall that particular case?
Yes, I prepared for this. I have this in written form, but I would disagree with what you mentioned. In that case, the subject of the second appeal examined by the panel referred to the control of legality in that appeal in relation to the actions of the bailiff, but not for the matter, the substance of the case.
Okay, I understand your position on that, and let me ask some follow-up questions. First, in round two of the questions, you stated that the decision by the Court of First Instance in 2014 approving the settlement that set the visitation rights, you said that the visiting schedule was defectively worded. Can you explain what you meant by that?
So to continue this idea, I will tell you that we've looked into the legal actions of the bailiff and we did not look at the judgment because the law is restricting us to do this according to the principle of availability. All the second appeal referred to the legal actions of the bailiff because in the transaction of reconciliation between the parents that was concluded, it was not foreseen a way to indicate the obligations of the mother, but the bailiff increased basically by him or herself this fact without going to court because the law says about a form when for at the request of the bailiff or parties in the process to come with such a proposal and to explain on the ruling or to omit the contradicting provisions if this change the without changing the judgment. But in that case, the Court of Appeal executed the judicial control of the documents and the judgment in the procedure that they were referred the matter. They had no competence to accumulate the materials to prove the reconciliation of the parents.
Okay, let me take this in steps just to make sure that I understand you. So I first understood both from your statement today and from your written answers that in your view the Court of Appeals focused solely on the legality of the bailiff's actions, correct? And the bailiff in this case, in your view, acted illegally by bringing an enforcement where there was a disagreement between the parties over the meaning of the settlement agreement. Is that correct?
It was about transaction. So this bailiff had to go to the court that issued a judgment, meaning approving the reconciliation transaction, where it should have be given some explanation about the obligations of the mother. But the transaction did not involve any obligation from the mother.
And
So, in a wrongful way, he imposed or she imposed the mother to meet some obligations, but that transaction did not foresee such aspect.
And the European Court of Human Rights, you may recall, observed that it was formalistic by the domestic courts to analyze the case that way because the transaction recognized the right of the father to take the children, to have the children for visits. But the domestic court, the Court of Appeals, said there was not a statement in the transaction saying the mother had an obligation to give. Is that?
When we've looked in the case, we did not look in the substance of the case, on the merits of the case. We looked only at the transaction, only at the actions of the bailiff about obliging the mother. But he or she extended their actions, their scope, by including that obligation when actually this was not included in the reconciliation. And if that was to be examined on the merits about this reconciliation transaction, you should believe me that this transaction would have not been approved because in every transaction the parties have obligations, otherwise this is not approved. This is why we've explained to the bailiff. You should submit a request to the court issuing this reconciliation transaction to explain to you about the extension of the transaction, which was approved by a court decision. And when taking the decision, the judge would have explained the way how to extend the the scope or the obligation. And in that case, that would have been included as an obligation in the decision, because the bailiff cannot extend by themselves the court decision, even though if it refers to this transaction or peace treaty, if we call it like this.
So, if I've understood you correctly, you're saying that in these circumstances, the father, in order to protect his rights, would have had to initiate an action in the lower court to clarify the transaction? Or should the bailiff have done that at the father's request?
The bailiff, actually. The bailiff had to. Because he was restricted in those conditions from the transaction, and not the father, but he had to go.
All right. Judge, I don't think we have any other questions on that matter. Let's turn to the cases that we've referred to in our notice, and I think you've referred to in your responses as the non-enforcement cases, the cases involving whether judgments were enforced within a reasonable time. This is another area where ultimately there were rulings by the European Court of Human Rights that there'd been a violation of certain provisions of the convention. There were 3 cases that were before the Court of Appeals that were just dismissed. They were claims where parties brought actions under law number 87 of the year 2011 seeking damages. And in the dismissals, the Court of Appeals observed in one case that there was not available funds, in another that the petitioner was obliged to wait their turn, and then in a third that the petitioner was no longer eligible because it was preferential housing and the person no longer had the position. My question is this: law number 87 did not identify those reasons as a basis for denial of recovery. So how is it that the dismissal could be appropriate for those reasons?
If I understood you correctly, I will try to explain and to support, to justify this position. The Commission refers to social accommodation. This refers to civil servants with special status and special guarantees, and Holov Gerbe and the others are former police officers, or officers, maybe police officers right now. I don't know when where they given or signed by court decision the living spaces. This was given to them for the fact that they were police officers. During the reference period, those were job-related services, but not social living spaces. So social accommodation has and job-related accommodation have different purposes. Social places are meant for persons with low income or being vulnerable, and having the aim to give a safe place to stay and accessible place to stay for those who cannot afford to have a place to live on the free market.
Judge, excuse me, I appreciate what you're saying, and we've received your written statement and understand it. So I understand your point that this is preferential housing, not social housing. The question that I ask is, given that Law 87 did not identify as bases for denying claims the reasons articulated by the Court of Appeals, how should that have resulted in the dismissal? Why were these claims dismissed for reasons not identified in the law?
So about this, the cases for the damages for the non-enforcement in due time of the judgment, we have the rules of civil obligations, and in that case, the parties have the obligation to present evidence. Ministry of Justice, according to Law 87, the probation burden of proof is on the parties. So it had to be proven that there was not this enforcement in due time, and this is from the Ministry of Justice. And the burden to prove the damage that exists and the costs and the expenditure for the trial are on the defendant, on the claimant. So in that case, the Ministry of Justice issued a reference document decision saying that the deadline was not violated for the enforcement, and they requested to refuse the action, the claim. But when we talk about some amounts that are indicated, which should be taken as a benchmark, goes in contradiction with the practices at that time. Those practices were different, and the Supreme Court of Justice would invite us to have workshops to tell us about how to apply those. But actually, all those decisions that were challenged in the Supreme Court of Justice went in contradiction with the recommendations, and those judgments were kept. Stood by.
So are you saying that I'm sorry, I just want to make sure I understand your position on this. You're saying that these actions were dismissed at the request of the Ministry of Justice because it argued that there had not been unreasonable delay?
Yes, not enforcement in non-due time was not confirmed.
Okay, and I think the last statement you were making is that when there was a further appeal to the Supreme Court, it upheld the actions of the Court of Appeals? Okay.
Yes, they stood by it.
Do you have any other questions? Well, Judge Panov, I think we've concluded our questions. Let me then return to what I said earlier. You're allowed, if you would like, to make a brief closing statement. Is there anything else you would like to tell us?
At the end of this quite complicated procedure in which I engaged to contribute to the reform of justice and to build the trust of public in the judiciary, with the risk to sacrifice the 35 years in the judiciary, I believe I was quite explicit to contribute to the traceology of my financial movements and my professional background, giving you some specific about the style of life of the judges and financial culture, and also living the conditions that which the justice has functioned in the last 12 years. I am aware that the specific of our national justice is difficult to be understood by a foreign arbiter, but this could not, I believe, affect the purpose of the vetting procedure. I really hope I was explicit in my statements, and I've managed to make transparent my financial situation and my family's situation in relation to the practices analyzed by the Commission. I am grateful to your patience and respect that you showed in the full evaluation process. I want to say that I've been working in the judiciary since 1990. I've been through a lot of challenges. It was a very difficult period, but I want to thank you. Well, obviously, this period is different from that period, but in the 90s, in the 1990s, I was a judge in Bender. The war started at that time. We had some very difficult challenges when I had to flee that war. In the 90s, I was working for the Central Court, Chișinău. It was called, but now we are treated very well as judges. I want to thank you because we have the contribution of the state and the contribution of the European Union regarding the appreciation showed to our work as judges. Thank you.
We've come now to the end of today's hearing. Judge Panov, thank you for your answers in response to our questions today and your previous answers to the Commission's questions before the hearing. After the hearing, the panel will approve an evaluation report stating its conclusion whether the subject meets the criteria for ethical and financial integrity under law number 252. The panel will strive to complete and approve its evaluation report and announce its conclusion as soon as possible. This hearing is now closed. Good day to everyone.